Let's continue here tonight. The DA wants Parliament to withhold the IPID Amendment Bill from public comment. It suggested that the bill might be unconstitutional. The draft law is expected to address, among other issues, IPID's authority and court judgments affecting law enforcement officers. A glaring court case is that of former IPID head Robert McBride, whose suspension in 2016 was found to be unconstitutional. We're joined now by DA Police spokesperson Andrew Whitfield. Andrew, good evening. Thanks for your time. So let's talk about the issues that you're raising with this amendment bill. What in particular do you have a problem with?
Well, thank you very much, Kathy. I mean, the fundamental problem here is that the national government is not giving full expression to the key word in IPID, which is independence. And we know from the McBride judgment that the manner in which McBride was removed and suspended and ultimately dealt with from a disciplinary point of view was found to be unconstitutional. That was dealt with in Parliament through a separate amendment bill. But what wasn't dealt with was the appointment process for the executive director. And there were two constitutional court judgments. The one was the McBride judgment. The other was the Glenister judgment. And the bill that we are now supposed to be dealing with is really fundamentally supposed to create more independence and transparency around the appointment process. And what happened is that last year, government gazetted the bill for public comment. What then happens is that Cabinet reviews those comments and sends the bill to Parliament. They've now sent us a fundamentally different bill. And Section 4 of the bill, which deals with the appointment process of the executive director, no longer has the original independence written into it that was there last year. And we believe that is fundamentally procedurally flawed, but also potentially unconstitutional.
Questions of the independence of IPID go directly to whether it is effective in carrying out its mandate. And I think that's really at the heart of the issue, that we have an organization here that is supposed to independently look into matters, including those of police officers that are rogue or accused of wrongdoing. But because they rely on the police for budget, they share resources in some instances, including investigative capacity. It, of course, really does muddy the waters.
Well, if you want a police watchdog that can bite, you have to give it teeth. And the teeth in this instance are independence. You cannot have a minister of police who appoints the executive director. There needs to be an independent process. That's the first step that we need to take to secure the independence of IPID. And even with limited resources, if they were given more independence and more teeth to bite, I think that we would see far more improved results from IPID. The other thing that needs to be secured, aside from independence, is obviously adequate resourcing. But on the policing side, what happens, Kathy, is that within the SAP's disciplinary regulations and regimes, they ultimately contradict the findings of IPID. So IPID presents recommendations to SAPS. SAPS conducts its own disciplinary process and ultimately contradicts the findings from IPID. And we know that of, I think, about 10,000 complaints over the last few years, only 50 of serious police abuse, only 50 SAPS members were suspended. And so there's just simply no consequence management within SAPS. And that is why we have to strengthen IPID and why Parliament needs to prevent this bill from being processed, because Cabinet is trying to get us to rubber stamp something that is clearly unconstitutional. And even the Office of the Chief State Law Advisor has not signed off on this bill. It's unheard of.
If you don't want the minister to be the one making the appointments, which independent process would you suggest? Who must be making the appointment?
Well, we've long been calling for a panel of experts to be involved in the shortlisting and interview process, and ultimately for the parliamentary committee in a recorded session so that the public can also see what's going on, that there's a parliamentary committee that interviews the prospective candidates, and that then Parliament then makes a recommendation to the minister, as opposed to being given a predetermined a candidate that we simply have to rubber stamp. And I'd like to remind your viewers that the current executive director, who I believe is doing her utmost best, was appointed under very unfortunate circumstances where the committee wasn't even given an opportunity to debate the issue, let alone interview the candidates. And so I think that there's a three-tier process. The one is a professional panel of experts chaired by a retired judge in order to preside over the interviews. Parliament to conduct a secondary level of interviews to scrutinize the candidates in front of the public in a live recorded session. And then ultimately Parliament to make a recommendation to the Minister as to who the candidate should be, not the other way around.
When it comes to the questions of constitutionality, we certainly have previously seen, legislation that was questioned or even criticized being signed even by the president, but then being opposed in court following the finalization. What process do you anticipate will unfold here?
Well, I sincerely hope we don't ever have to get there. This is so patently and obviously flawed from a procedural point of view and from a legal constitutional point of view. The entire purpose of this bill was to address the shortcomings that were found by the Constitutional Court. It does not do that sufficiently. In fact, the entire section, as I said, which is Section 4, that deals with the core arguments around independence, has been rewritten and transferred the powers back to the minister. So that is why I wrote to the chairperson, the acting chairperson of the committee, requesting that Parliament solicit a legal opinion on the constitutionality of the bill, and that before Parliament now processes this bill and conducts parliamentary public participation, that at the very least we be able to meet as a committee and decide, based on that legal opinion, whether we should go forward. And the reason that I'm saying I hope we don't have to go through the whole process is because it comes at a cost of millions of rands. Public participation and the processing of legislation, this is not something that should be taken lightly. It is something that really needs to be thought through, because ultimately Parliament would be failing in its duty to conduct effective oversight of the executive if we simply allow a bill that has fundamentally changed in the last 12 months from when it was first gazetted to now that it's serving in Parliament and it reads completely differently. If we simply rubber stamp that, we are nothing more than an extension of the Cabinet, and that is a gross failure of our duty as Parliament.
The DA Police spokesperson, Andrew Whitfield, thanks for your time tonight.